Friends, the decision by the Supreme Court on the release of the assassins of Rajiv Gandhi is highly discouraging, dispiriting, and it is entirely untenable, undefendable, and inarguable. Friends, justice has to be done, but also has to be seen to be done. Today, the Honorable Court has ordered release of six convicts who had carried out the brutal, premeditated, and heinous assassination of a former Prime Minister of the country, the late Rajiv Gandhi. This release has shocked the nation's conscience and has invited serious concern and criticism from all sides of the political spectrum. Following a previous judgment of 17th May, when another person was released, relief was granted to six convicts today to allow them to walk free. Now, I'd like you to please focus on the six reasons I'm giving why we object. But before that, first, it sends a message to the world, an undesirable message, that we extend to these killers the benefits of our judicial magnitude and largesse, forgetting the nature of their crime. After all, they murdered in cold blood and by deliberate design a former prime minister. Second, even the Supreme Court has repeatedly said in other judgments that there is no blanket guarantee to be released just because you have served a certain amount of time. The court observed many judgments are there. One of them is Gujarat versus Narayan. There is no absolute right to release, and each case must depend on the context and facts of his own case, individual merits. Third, the Supreme Court has justified its decision today and the 17th May decision, saying that the release was recommended by the state of Tamil Nadu. Our most humble and respectful view is that the ultimate arbiter in these matters is the Supreme Court, not the state of Tamil Nadu. And to give this dispositive weight to the Tamil Nadu government is itself legally erroneous. Therefore, we frame the following questions for the nation through you in the light of today's verdict. Question 1: why has the Honorable Apex Court, despite being aware of the nature of the crime, the evidence that led to their conviction, the previous objection of the governor, even sought to grant preferential treatment to those individuals who were convicted, I repeat, convicted, of so reprehensible, so horrific, and so heinous a crime? Second, how will the Apex Court in the future deal with similar claims by several other similarly placed or even less seriously placed criminals or accused, or rather convicts, not accused? How can the Supreme Court now refuse other similar claims, regardless of howsoever heinous a crime has been committed? Friends, third, if ill health is a ground for release, if good behavior is a ground for release, if conduct in custody is a ground for release, then why are so many individuals still in custody across the country, especially so many suffering under charges brought by this government? The Honorable Supreme Court cannot be selective in applying these standards. Most important, friends, is the fourth point I'm making. The assassination of a former Prime Minister stands on a totally different footing. Irrespective of political color, such a person is reflective of the insignia of the sovereignty of the country. In that sense, a fatal attack on any PM, former or sitting, is an attack on the very sovereignty and integrity of India and cannot be dealt with on normal administrative considerations. And therefore, we endorse and support the very clear stand of the central government, which did not agree with the state government on this issue. If the petitioners before the court, that's the fifth point I'm making, were seeking relief, so the petitioners before the Supreme Court were seeking relief, the principal respondent, the state, was supporting the petitioners. Then it was incumbent upon the Honorable Court to not only call upon the central government as they did, but to give a lot of weight to the fact that the central government did not agree with the state government. The degree of weight, the dispositive weight given to the state government is disproportionate to the weight given to the central government's view. And we believe that not sufficient weight was given so that the central government's clear disagreement with the state government could be fed into the calculus appropriately. Sixth, the somewhat strange and possibly unintended effect of this order, strange and possibly unintended, hopefully unintended, would be that any recommendation by any state government would be virtually binding. And it would be taken as virtually dispositive by the Supreme Court, which cannot be correct. And most important, lastly, not the least, but very important, this is underlined by the fact that the court itself was cognizant of this because they used their special unique powers under Article 142, which is indicative of the absence of their power to do a specific thing. Because 142 is used only because you don't have the power and you want to do some overall special justice, which only the Supreme Court has the power. The Indian National Congress respectfully believes that this is a wholly inapposite invocation of the drastic, ad hoc, and unique power of the apex court in a case involving convicted assassins of a former head of the Indian government, which, as I have explained earlier, strikes at the very root of Indian sovereignty. Without going into specifics, I only want to say that we intend to take all appropriate remedies available to us, be it review or any other form of legal redress, because we believe that we owe it to the people of this country and to the Supreme Court also on the legacy which it has built itself. कर रहा हूँ अभी तो खत्म सांस भी नहीं लिया इंग्लिश खत्म करने के बाद No, please, you have come late and you want to ask a question before Hindi. That's very unfair, Sunil. Very unfair. No. No. दोस्तों, मित्रों, ये ध्यान से सुने सभी संस्थान कि व्यर्थ में नहीं जाने देगा ये देश राजीव गांधी का बलिदान. इसलिए हमारा आदरपूर्वक निवेदन और आह्वान है न्यायालय को कि नहीं दें गुनहगारों को जीवन दान. देखिए, न्याय होना भी चाहिए और दिखना भी चाहिए, प्रतीत भी होना चाहिए. आज उच्चतम न्यायालय ने 6 ऐसे व्यक्ति जो दोषी या अभियुक्त नहीं हैं लेकिन कन्विक्टेड हैं, एक ऐसे फौजदारी कारनामे के लिए जो एक पूर्व प्रधानमंत्री की हत्या का कारनामा है. और सबसे महत्वपूर्ण बात है कि राजनीतिक रंग कुछ भी हो, एक पदासीन प्रधानमंत्री या पूर्व प्रधानमंत्री पे घातक हमला और मृत्यु और हत्या भारत की अक्षुण्णता, संप्रभुता, भारत के अस्तित्व को अटैक करता है, उस पर आक्रमण करता है. इसमें कोई राजनीति का रंग नहीं होता. और ऐसे एक जो अपराध है, जघन्य अपराध, उसके लिए आप आम तौर वाले प्रशासनिक कारणों से 6 लोगों को और एक व्यक्ति को पहले मई 2022 में रिहा नहीं कर सकते. ये कांग्रेस का आदरपूर्वक स्टैंड है उच्चतम न्यायालय के निर्णय के विषय में. देखिए, आपको पता है, सबको, पूरा देश, पूरा विश्व जानता है कि आप कोई ऐसा संदेश नहीं देना चाहते कि न्यायपालिका के एक सौहार्द्र से ऐसे घिनौने, ऐसे जघन्य अपराध के लोग जो अभियुक्त नहीं है, कन्विक्ट हैं, जिन्होंने सोच समझकर प्लानिंग करके एक पूर्व प्रधानमंत्री की हत्या की, उसको न्यायपालिका किसी रूप से फायदा दे रही हो। सुप्रीम कोर्ट, उच्चतम न्यायालय ने खुद ने बार बार कहा है कि सिर्फ अगर आपने कुछ समय कारागार के पीछे बिताया है, वो कारण नहीं हो सकता रिहाई का। कई निर्णय हैं, स्टेट ऑफ गुजरात वर्सेस नारायण एक निर्णय है। हर केस को उसके संदर्भ में देखना पड़ता है, और पूर्व प्रधानमंत्री की हत्या से बड़ा संदर्भ कोई नहीं हो सकता। तीसरा, उच्चतम न्यायालय ने बहुत हद तक एक सर्वोपरि प्रधानता दी है तमिलनाडु प्रदेश के स्टैंड को कि उनको रिहा करना चाहिए। हमारा आदरपूर्वक निवेदन है कि अंतिम शब्द तमिलनाडु सरकार का नहीं होता, अंतिम शब्द उच्चतम न्यायालय का होता है, कोई भी स्टैंड लिया हो तमिलनाडु सरकार ने। इस संदर्भ में मैं 5-6 प्रश्न बड़े संक्षेप में पूछना चाहता हूं, बल्कि प्रस्तुत करना चाहता हूं, पूछना तो नहीं है, प्रस्तुत करना चाहता हूं देश के सामने आपके जरिए। पहला, कि जो जघन्य अपराध पूर्व प्रधानमंत्री की हत्या में निहित है, क्या उस केस में आप इस प्रकार का प्रेफरेंशियल शब्द महत्वपूर्ण है, ट्रीटमेंट दे सकते हैं उन लोगों को जो कन्विक्ट हो चुके हैं उच्चतम न्यायालय तक ऐसे जघन्य अपराध के लिए? दूसरा, भविष्य में इस प्रकार के अपराध या इससे कहीं ज्यादा, कहीं कम गंभीर अपराध, उसमें उच्चतम न्यायालय मना कैसे करेगी रिहाई का, अगर ये प्रेसिडेंट मान लिया गया तो? तीसरा, अगर रिहाई का कारण स्वास्थ्य अस्वस्थता है, अगर रिहाई का कारण काफी समय बिता देना है जेल में, अगर रिहा का कारण अच्छा एक कॉन्डक्ट है जेल के पीछे, तो मैं समझता हूं कि ये हजारों ऐसे व्यक्तियों को लागू होता है, लाखों को, जो आज गलत चार्जेस पे भारतीय जेल्स में पड़े हैं। उच्चतम न्यायालय किसी रूप से एक तरफ ध्यान नहीं दे सकती और उन सबको भुला दे या उनकी विद्यमान होने की प्रक्रिया को इग्नोर कर सके। चौथा, पूर्व प्रधानमंत्री का जो एक हत्या होती है, वो ये सबसे महत्वपूर्ण मुद्दा है। ये चौथा मुद्दा, पूर्व प्रधानमंत्री की हत्या, जैसे मैंने कहा, भारतीय संप्रभुता, अक्षुण्णता, भारत की इंटेग्रिटी का विषय है। राजनीतिक रंग कोई भी हो, प्रधानमंत्री पदासीन हो या पूर्व हो, ये भारत पर आघात होता है। उसको आप आम कोई अपराध नहीं मान सकते और उसको आम प्रशासनिक कारणों से रिहाई नहीं दे सकते। ये बड़ा रोचक मामला था। पांचवा मेरा बिंदु, याचक रिहाई चाहते थे, जो मुख्य प्रतिपक्ष था प्रदेश सरकार, वो उनका समर्थन कर रही थी। इस सिनारियो में मैं समझता हूं उच्चतम न्यायालय बाध्य था कि केंद्र सरकार जो विद्यमान थी, उनके मत को भी पूरा वजन दे, ज्यादा वजन दे। केंद्र सरकार ने कुछ भी कहा हो, लेकिन यह तो स्पष्ट है कि केंद्र सरकार प्रदेश सरकार के मत से असहमत थी। लेकिन प्रदेश सरकार के मत को इतना ज्यादा वजन देना कानूनी रूप से गलत है, जबकि केंद्र सरकार ने कभी उस मत से सहमति प्रकट नहीं की। छठा, इस परिणाम का एक बड़ा विशेष, एक बड़ा आश्चर्यजनक परिणाम भी हो सकता है इस निर्णय का, और वो आश्चर्यजनक परिणाम ये है कि प्रदेश सरकार का जो भी सुझाव होगा रिहाई का, वो करीब करीब बाध्य मान लिया जाएगा उच्चतम न्यायालय द्वारा। ये हो ही नहीं सकता, ये कानून में गलत है। और अंतिम, सबसे महत्वपूर्ण, उच्चतम न्यायालय इस बात का संज्ञान उन्होंने लिया है, वो जानते हैं कि कोई ऐसा प्रावधान नहीं था उनके पास जिसके अंतर्गत ये रिहाई का आदेश हो सकता था। इसीलिए प्रयोग हुआ 142 अनुच्छेद का, जो बना है सिर्फ उच्चतम न्यायालय के लिए और जो उन विशेष केसेस में लागू होता है जहां और कोई पावर नहीं हो। तो आप एक विशेष प्रावधान संविधान का इस्तेमाल कर रहे हैं, किसके लिए? पूर्व प्रधानमंत्री के जघन्य हत्या के कांड में। मैं समझता हूं ये उपयुक्त नहीं है, ये गलत है, और इसलिए हम विनम्रता पूर्वक कहते हैं कि हमारे पास जो भी कानूनी विकल्प होंगे वो हम इस्तेमाल करेंगे और हम प्रार्थना करेंगे मान्य न्यायालय से कि ये निर्णय खड़ा नहीं होना चाहिए. Now, first questions on this, there is something else. I've already said so 3 times. I've said so. No, this is the same thing I have already said in my statement. I've said that we have expressed our view very clearly, very categorically. Whatever rights are available, I don't want to limit it to review because criminal law review has some narrower connotations. But whatever rights are available to us, we shall certainly try and exercise them. But it is more important to make our stand clear in front of the nation through you. And that is what I'm doing. And I think that is even more important than anything else.
Views were diametrically opposite to what Mrs. Gandhi, what Rahul Gandhi and Priyanka Gandhi Baba, when Priyanka Gandhi went to relocate, like, against what.
We understand your question. Now, you know when Mrs. Sonia Gandhi gave this personal statement, how many years ago? Do you know when the Rahul Gandhi and Priyanka Gandhi gave this statement years ago? What was our reaction from this very podium? So we are very consistent. This is an institutional matter. It's a matter where, for example, to give you an example, where my views are the same as the central government's. So this is not politics. This is not political color. Certainly, Mrs. Sonia Gandhi, above all, is entitled to her personal views. But with greatest respect, the party does not agree with that view, has never agreed with that view, and has made our view consistently clear to you for the last, what, decade or so. And we stand by that view. Because according to us, and this is the most important aspect, the sovereignty, the integrity, the identity of the nation is involved in a prime minister's assassination, sitting or former. It doesn't matter whether you are prime minister, she's prime minister, I'm prime minister. It doesn't matter your color is X, Y, or Z. And that is the continuity we are talking about. And that is perhaps why the central government has also never agreed with the state government view on this regard. Previous central government and this central government. No, we expressed, we made a statement. And today I have again said that the fact that you. No, that's all right. That, you see, legal redress beyond a point in a matter where we are not directly parties has its own limitations. Legal redress is not what we are here before you. Through you, we are before the nation. Whatever we can do in law, what is maintainable, we will try. But that's not the point. The point is that this is a much larger issue. Issue number one, which is larger, is why should the Honorable Supreme Court invoke special powers under 142, which nobody in the country has, for the convicted assassins of a former Prime Minister? Is there an issue on which I can address the nation through you? Answer is yes. Second issue is, has the larger issue of sovereignty and integrity of the nation typified in the personality of a prime minister who is the insignia of that sovereignty? Has that aspect been taken into account before exercising the extraordinary power? Third, mere administrative considerations cannot be the ground, as it might be in a lesser or an ordinary offense. I'm not conceding, I think might be.
That means there is a central legislation, central law that was, in terms of convicts, they were charged under those acts. State does not have the power to use a central prohibition.
Our point is that no entity in the country has dispositive power. You have to give a lot of weight to all entities, but in particular to the central government, because this is not, all murders are horrible and heinous, but this is not a local murder in a locality in Tamil Nadu. This is a national issue. And therefore, whether or not the central government was not forthcoming or did not appear frequently or did not take a stand, the fact of the matter is that no central government has agreed with the state government for some years when this has been going on. And this central government has specifically disagreed with this state government. So I think that has to be given weight. The principal reason given is that because the state government is saying so. Yes. Who was the former president of our party? Sonia Gandhi. If I'm able to disagree with her on this podium, I'm going to agree with the ally government in Tamil Nadu. No, our stand is clear for last 10 years. Tamil Nadu stand has never been ours. I don't know how many times we have said this, but today we have said specifically because there's a release order. Has the Tamil Nadu government, my stand, ever coalesced? Never. Irrespective of political color in that state also. Their stand and our stand has been different. Yes. I've given you the entire briefing on that. I can't say more than that. How can I answer what led them to? I have critiqued the judgment in the most respectable terms, and I have given you the reasons for my criticism. That's all I can do. I can't get into the mind of anybody and say this. अच्छा, अब किसी और मुद्दे पे चलते हैं साहब, चलिए। आ रहे भैया, आप आते लेट हो, पूरी हिंदी में ब्रीफिंग हो गई, खत्म हो गई। आप कितना लेट आए हो? आप तो सुनील प्रभु से भी लेट आए हो ज्यादा। आप आज सिर्फ 3 मिनट लेट थे। अरे सॉरी, मेरे को ये बड़ा इंपॉर्टेंट प्रश्न है, वो आईपैड, ये मैं आपको बताना चाहता था, मैं आपको जरा इसके बारे में बता दूं। ये भी अपने आप में टाइम लगेगा थोड़ा सा, 5 मिनट दे दीजिए मेरे को। हम इतने जिम्मेवार, कुछ ज्यादा ही जिम्मेवार हैं। हम 2 दिन रुक गए ये बोलने के लिए कि संजय राउत के विषय में जो निर्णय आया, इसलिए नहीं रुके कि हमें बहुत ही गलत लगा ईडी का पूरा रवैया, लेकिन इसलिए रुके कि उच्च न्यायालय में ये मामला लग रहा था। तो हमने कहा कि अगर पॉसिबली इस निर्णय में कोई दखलंदाजी होती है उच्च न्यायालय द्वारा, तो हम उसके लिए इंतजार कर लें। अब वो मामला अभी सुना नहीं गया है और इसलिए हम उसके लिए इंतजार नहीं करेंगे। मैं आपको कुछ बातें बताना चाहता हूं बहुत संक्षेप में, क्योंकि ब्रीफिंग तो हो गई है, लेकिन ये प्रश्न एक दूसरे मुद्दे पे है। देखिए, आपके सामने ये निर्णय, और अगर आप चाहें तो मैं ये बुकमार्क कॉपी, क्योंकि बहुत समय लगेगा आपके पास, मेरे पास समय नहीं है इतना कि आप लोग इसको नोट करें, मैं आईसीसी को दे दूंगा। ये बुकमार्क है, इस पे जो बुकमार्क है वो पढ़ लीजिए आप सिर्फ। ये आपको कोई करके नहीं देगा, बुकमार्क पढ़ने के लिए आपके लिए सहूलियत है, वो पैसेजेस बड़े सामने। इससे जाहिर है कि इस देश में ईडी एक रनवे गाड़ी की तरह है, एक बिना पायलट के हवाई जहाज की तरह है, एक बिना ड्राइवर के रॉकेट की तरह है, जो किस दिशा में जा रही है, किस गति से जा रही है, किसी को पता नहीं है। ये जो हैं इसमें फैक्ट्स दिए हैं, वो चौंकने ही नहीं है करने वाले, लेकिन भयानक हैं, घबराने वाले हैं, डराने वाले हैं। और हमें समझ नहीं आता कि ऐसी सरकार इतने समय के लिए ये कैसे चलने दे रही है। मैं आपको 2-3 इसके पक्ष पढ़ के बता दूं, बाकी मैं आपको एक बुकमार्क कॉपी भेजूंगा। पैरा 23 में लिखा है, admittedly there was no FIR for the allegations and circumstances of transactions of 2006-7 till the resignation of Praveen Rawat. 2018 FIR was lodged, which is after 11 years. It is bounden duty and obligatory on the court to sit in the armchair of the contemporary period and examine those facts associated with it. ये हुआ एक। दूसरा, पैरा 27, आप ये नोट कर लें, आपको सब मिल जाएगा, ये भेज देंगे आपको बुकमार्क कॉपी। It is therefore apparent to hold that until 2011 February there was absolutely no element of cheating, no intention to cheat and induce 672 occupants and MHADA nor any criminal conspiracy. मैं किसी के लिए ब्रीफ नहीं आर्ग्यू कर रहा हूँ, मैं कह रहा हूँ कि कोई हो, आप हो, ये हो, मैं हूँ, रावत हो, वो चौथा पांचवा आदमी हो। देखिए, सरकार कोई भी रंग की हो, इस प्रकार के तथ्यों पे क्या कोई ईडी एक्शन इनिशिएट कर सकती है? ऑन द कॉन्ट्ररी, जिस बारे में रावत को अरेस्ट किया गया, ऑन द कॉन्ट्ररी द हाई कोर्ट हैड अप्रिशिएटेड द डेवलपमेंट वर्क एंड प्रोग्रेस ऑफ MHADA इन दैट प्रोजेक्ट। ये जज लिख रहा है। All this prima facie further goes to show that the said development activity of 2008 was not intended dishonesty to induce and cheat 672 tenants. Number 3, no FIR of contemporary facts. Admittedly, there is no FIR for the alleged contemporary acts during 2007 to 2011. Much later in 2018, it is revived. This is the other part of it. Then next, transfer of FIR to third party is unfounded. ये पैरा 54 है। मैं आपको संक्षेप में दे रहा हूँ, जल्दी जल्दी कर रहा हूँ क्योंकि आपके पास इतना नोट करने का भी समय नहीं है। हर फाइंडिंग अलग है, तो आप इनिशिएट कैसे, इतना आप हल्ला कर रहे हैं अखबार में, इतना प्रकाशित कर रहे हैं, दिन प्रतिदिन मानहानि कर रहे हैं, मजाक उड़ा रहे हैं, लीक कर रहे हैं, और एक्चुअल तथ्य ये है, किसी व्यक्ति को एक दिन, 3 महीने और 6 महीने तो बहुत होता है, एक दिन क्या इन तथ्यों पे आप रख सकते हैं? ट्रांसफर का बोल दिया, एप्रोबेट रेप्रोबेट पढ़िए। सेल्फ कॉन्ट्रडिक्टरी, सेल्फ डिस्ट्रक्टिव, इनकम्पैटिबल स्टैंड्स टेकन बाय ईडी कैनॉट बी एक्नॉलेज्ड एट लॉ। मैं पूरा पैरा नहीं पढ़ रहा हूं। All this is nothing but a classic example of approbate and reprobate which cannot be acknowledged at law. मैं आपको कुछ भयानक चीज बता रहा हूं कि ये चीजें हैं, तो हम किस प्रकार की एजेंसी द्वारा नियंत्रित किए जा रहे हैं, इससे आपको मालूम पड़ता है। और सबसे महत्वपूर्ण है, बाकी में कई सारे और हैं, समय कम है, सबसे महत्वपूर्ण है कि उन्होंने कहा है कि कभी भी ईडी गिरफ्तारी के बाद कन्विक्शन करता ही नहीं है। बड़ा मजाकिया चीज है। इन्होंने कहा है पूरा, इसका मैं आपको पैरा दे दूं, 113 नंबर पेज में, 146 पैरा नंबर। Experience of this court has constrained me to note that in every ECIR, the speed of the ED in arresting accused is extraordinary. ये मैं नहीं कह रहा हूँ। Even in every matter, the whole period of 14-15 days prescribed under CRPC is consumed and exhausted in seeking custody. Once any accused is remanded in custody, the pace taken by ED for arresting him automatically gets down to zero. Arrest करने के बाद सब कुछ zero. सड़ते रहो, पड़े रहो. Once the applicant files bail application, ED takes at least 3 to 4 weeks to file reply. In the instant case of facts दिए हैं. Apart from this, in every matter, it is noticed that ED takes very, very long time to reply to any simple. I am constrained to refer to another example, that is of delay. I am constrained to note that not a single trial right from the establishment of this designated court has the ED concluded by leading evidence, and the court could not give a single judgment for last 10 years. इस प्रकार से राजनीतिक प्रतिशोध, राजनीतिक प्रताड़ना और राजनीतिक द्वेष प्रैक्टिस किया जाता है इस देश में. This court has submitted a detailed report to the Honorable Principal Judge regarding such modus operandi. In every case, the PMLA, the ED says, further investigation is going on in each and every case. Even in cases where this court has framed a charge, it could not record evidence of more than 1 or 2 pages. तो इसका क्या उद्देश्य है? बड़ा सरल है, मैं ज़्यादा नहीं पढ़ूंगा ऐसी बात. उद्देश्य है कि एक बार अरेस्ट कर लो, उसके बाद चलाओ जेल में, और उसके बाद जो होना है सो होगा. मैं समझता हूँ इसमें अंग्रेजी बोलने की जरूरत नहीं है. आई ओनली वांट टू से ऑल द कोटेशंस आर हियर. Startling, terrible, shocking, deplorable findings have come to light about the conduct of ED. This agency is clearly an instrument of harassment, torture, pain, and oppression. The judge has recorded clear findings which I have read to you. The paras are known to you. No FIR is filed for decades in this case, in the Raut case, for almost 10 years. No convictions are done, not even one conviction. In fact, not even one trial completed, forget conviction, not even one trial completed before this designated court. The approach is to arrest and leave him languishing in jail. Self-contradictory approaches of approbate and reprobate, and therefore, this is a misuse of sovereign authority, is what the court is saying. Thank you. मैं दोनों भाषा में इसलिए बोल दिया because ये we were ready with this yesterday and day before. We did not take it thinking that the High Court is going to reach the matter, but it's not reached, so we feel free to take it now. Oh, sorry, आपकी आवाज. हाँ. See, I have had a full briefing. I took the briefing on Bilkis Bano. According to me, there can hardly be a more reprehensible case for release in this manner. Now, you want to add salt to the wounds of the victims. You put a fair sprinkling of salt by felicitating them. You now put a bucketful of garlands at their feet by requesting them to be the nominee of your party. Imagine the angst, the torture, the pain of the victims and their families. We now know why they were released. Because politics is more important, the seat is more important, the election is more important. We know now why they were feted and garlanded and felicitated. It is the most terrible snooking of a nose, snooking at a nose at rule of law, at fair play, and striking terror in the hearts and minds of the victims. And with full state support and malpractices, you can imagine what these people, if elected, will do about the whole context of the society in which they live.
So your party in your home state is imploding again, and now we are seeing Hari Shafri opened up a new front against Mr. Ashok Gehlot on the OBC quota and sexual harassment. So how and what happens to Mr. Sachin Pilot's open report that he has talked about? So Venugopal said in a day or two you will have a decision. These are all statements that we are
In
not
a,
getting
you
across
are
yet.
asking you are asking things which are quite old. I will only, in a lighter vein, quote Mark Twain to you, who said, "The reports of my device appear to be highly exaggerated." That is what you are indulging in. But let me tell you that these are honest.
First advice is not
These
given.
are honest
You are
differences.
referring to your
No, no,
quote.
I am answering. No, I'm referring to your question. I'm referring to your exaggerations of Sunil Prabhu. Now, uh, let me be very clear that these are productive, honest differences or interpretations of issues like OBC reservation or ex-serviceman reservation, etc. Unlike the BJP, we are not a monolith, lips sealed with gum, fear writ large on our forehead party. A view is expressed which you are calling imploding. I totally disagree.
So will there be a change of leadership in the question mark?
There is only in your mind. In my mind, there is no question mark. There is absolutely no change of leadership of any kind happening. There is nothing going on, but you are asking leading questions. What is there for you to see. When the thing changes, we'll certainly inform you. Okay. See, I cannot react about the facts of an individual case, but I have read about it and let me tell you clearly. If true, even fractionally, it's a very serious matter because it is cross border, number one. Number two, in the Dera which you're talking about, who has been the biggest supporter and releaser on parole repeatedly? Earlier and now, repeatedly, the central government because they have the power. Thirdly, for such matters, we don't believe that politics should come in the way. Certainly, the two governments in issue here, the state government and the central government, should get at the bottom of this. I should not play grandstanding with you, you should not play grandstanding with me. Because the allegations sound very serious, but of course, we have to await. And I just hope and pray and trust that politics does not overtake what is actually a very serious national security issue, or at least an allegation at the moment. I said the center agrees with our stand. Huh? Huh? How can I talk about effort by government advocates? But you see, one thing is clear: the central government is total disagreement with the state government. That much is clear. Let me say that my effort is full, half, one quarter, zero. Let me assume, I'm not saying it is. The Supreme Court, which is the final arbiter, has to give very great weight to a disagreement of the central government and not treat the state government as overweighty or dispositive on so serious a national issue. The person who was assassinated was the prime minister former of a country, not even any state functionary. Okay, thank you. Thank you.